A non-disclosure agreement, NDA, is a powerful tool used by businesses, entrepreneurs, and professionals to protect sensitive information. It creates a confidential relationship between the parties to safeguard any type of proprietary or confidential information. However, while NDAs are generally legal and enforceable, there are circumstances under which they can be deemed illegal. Understanding these nuances is crucial for both parties involved in an NDA. Before discussing the conditions under which NDAs become illegal, it is essential to understand what an NDA typically covers. NDAs are designed to protect 1. Trade secrets. Proprietary processes, formulas, methods, and techniques that give a company a competitive edge. 2. Business plans. Strategic documents outlining future business activities. 3. Client lists. Information about clients that is not publicly available. 4. Intellectual property. Innovations, designs, and other creations of the mind. NDAs can be mutual, where both parties agree not to disclose information, or unilateral, where only one party is bound to confidentiality. When is a non-disclosure agreement illegal? 1. Public policy violations. NDAs that contravene public policy are unenforceable and illegal. Public policy is a principle that no one should be allowed to do something that harms the public. For instance, an NDA cannot be used to conceal criminal activities. Any NDA clause that attempts to hide illegal activities, such as fraud, embezzlement, or other criminal conduct, is void. Sexual harassment or discrimination. Increasingly, NDAs that attempt to silence victims of sexual harassment or workplace discrimination are being scrutinized and often found to be illegal. Several jurisdictions have enacted laws that limit the enforceability of NDAs in these contexts to promote transparency and justice. Chapter 2. Overly broad or unreasonable terms. For an NDA to be enforceable, its terms must be reasonable and specific. NDAs that are excessively broad can be deemed unenforceable or illegal because they restrict employment. NDAs that prevent an individual from working in their field entirely or that unreasonably restrict their future employment opportunities may be considered illegal. Courts typically strike down such clauses, viewing them as an unfair restraint on trade. Unlimited duration. NDAs with no time limitation are often considered unreasonable. While the duration of confidentiality obligations can vary, indefinite restrictions are generally viewed as overly burdensome. 3. Lack of consideration. In legal terms, consideration refers to something of value that is exchanged between the parties. An NDA without consideration is not a valid contract. This means that if one party is not receiving something of value in return for their promise to keep information confidential, the NDA can be deemed invalid and unenforceable. 4. Coercion or duress. An NDA must be entered into voluntarily by all parties. If one party was coerced, forced, or under duress when agreeing to the NDA, it can be declared invalid. Coercion or duress could involve threats, undue pressure, or manipulation, making the agreement unfair and not freely agreed upon. 5. Unconscionability. An unconscionable contract is one that is so one-sided that it is deemed grossly unfair. NDAs that are overwhelmingly biased in favor of one party, to the extent that they shock the conscience of the court, may be struck down.